afternoon. Welcome to today's webinar produced by intellectual property law firm Stern Kessler, Goldstein & Fox. Today we'll be talking about software patents. It's our second in a three-part series of webinars focused on the impact of the new USPTO Section 101 guidelines in a number of subject areas. All lines have been placed in a listen-only mode. If you have a question during today's presentation, please submit it via the chat box located in the control panel on the right side of your webinar screen. If we don't have a chance to answer your question prior to the end of today's discussion, we will follow up directly to make sure you receive an answer. As I've already noted as well, if you'd like to receive a PDF copy of today's presentation slides or a link to our recording, please send an email request to Aaron West. Today's presenters are Michelle Hallback and Sal Bezos. At this point, it's my pleasure to turn the call over to Michelle Hallback.
Thanks, Aaron, and thanks everyone for joining us on this call today. So as you likely know, on December 16th, the USPTO issued its interim guidance on patent subject matter eligibility. This guidance covered a wide range of topics and is intended to be applicable to all the judicial exceptions surrounding 101. The one we're specifically going to be talking about today is the abstract idea and the effects of the guidelines on software patents. What we'll first do is spend a minute on context and then jump into the guidelines themselves. We'll discuss the guidelines in the context of abstract ideas, what they mean, and how they apply to software innovation. We'll give you some tips for handling application and claim drafting for new innovation, and prosecution tips for applications that have already been filed and which are currently being examined. And then we'll finish up with a discussion of strategy, getting into substantive strategies for office action replies and also things to think about when considering your overall IP investment strategy in the software space. So let's take a look at just a snapshot of the history of 101 provenance. For the first 20 years, since 1952, when Section 101 made it into law, there were no issues until the glut of Supreme Court cases in the 1970s that resulted in the three judicial exceptions: law of nature, natural phenomena, abstract idea. In the 1990s, business method and software applications started to flourish, especially with the State Street decision in 1998. After a few high-profile cases involving business methods, such as the Amazon one-click patent and the Priceline Name Your Price patent, public perception changed and attacks on software began. So you can see that on this slide. The yellow circles there are the Federal Circuit cases, and we had Allopat, we had State Street, and those were primarily pro-eligibility. But then around 2010, with the introduction of the P.L.C case in business methods, things began to change. And so since then, we've had the trifecta of business method and 101 software cases. We had P.L.C followed by Mayo, which although Mayo was a diagnostics case, its test for 101 has since been applied in the software space as well. That also resulted in Alice. Alice mapped to the Mayo style of analysis for 101. And this prompted a series of Federal Circuit cases ever since Alice as well. The PTO has been given the job of trying to keep up with the changes in laws. So they've had a series of software guidelines or patentable subject matter guidelines. They issued a set just after Alice that dealt with abstract ideas, but then just on December 16th of 2014, they issued a new set of interim guidance. As I mentioned before, this is intended to be relevant to all the judicial exceptions, not just abstract ideas, but that's going to be our focus today. And with that, I'll turn it over to Sal to get into the details of what those guidelines said.
Thank you, Michelle. So on this slide, you can see an excerpt from the interim guidance. This is a flow chart that has been provided to examiners in order to help them craft rejections based on 101. And as you can see, the first step there is the familiar 101 language for what is statutory subject matter. But then steps 2A and 2B, which we'll get into detail here, is the language that's being drawn from the Mayo and Alice decisions. The step 2A of the analysis, which is really part 1 of the Mayo test and the Alice test, really talks about the issue of whether the claim is directed to an abstract idea. And in this context, directed to, and there was some question about this early on, and these guidelines really kind of solidify what that means. Directed to in this context simply means that it's recited in the claim. Now, of course, we're going to be focusing on abstract ideas here since we are talking about software, but this applies to any judicial exception, law of nature, natural phenomena. There's also, and we're going to go into this in more detail in the later slide, an option for streamlined analysis if the invention may or may not recite a judicial exception, but clearly does not preempt or otherwise tie up that exception. And then step 2A also talks about how you identify the judicial exception recited in the claim, and it requires that the examiner actually lay out that abstract idea. So on this slide, you can see some examples that are laid out in the interim guidelines of abstract ideas, and those come from a plethora of different cases that have issued before and after the cases we've talked about briefly. I'm not going to go into any of these in detail. They're here for your reference, but there's an extensive section at the end of the interim guidelines that really goes into detail about each one of these cases and provides examiners some guidance on how to apply that case law to their decision.
And one interesting thing here is the Patent Office went back to some older cases like Deere and Fluke and Benson and explained how the two-part Alice-Mayo analysis would apply in those cases.
And then at step 2B, which is part 2 of the Mayo test, examiners are asked to determine whether any elements of the combination of elements in the claim amount to something that's significantly more than the judicial exception, the abstract idea in the case of software. Specifically, the examiners are going to be looking for some sort of an inventive concept and some manner in which the exception is actually applied in a meaningful way. So even if there is an abstract idea that's come out of step 2A, part 1, the examiner is looking to see, okay, is there some meaningful, something more to this application of the abstract idea? Something else that's really critical to consider from the guidelines, and we'll talk about how to apply this when you're dealing with responding to an office action, but the guidelines do make it clear that every claim must be examined individually, and the elements of those individual claims that are recited therein need to be considered. And so the examiner cannot simply say, I'm addressing the independent claim, here's the abstract idea, there's nothing more, and then neglect to address the dependent claim. So what is significantly more when part 2 of the Mayo test talks about significantly more? Well, it's a number of different things, and the interim guidelines outline a number of options for what could be significantly more. Now, the Alice case identifies a couple of these: improvements to another technology or technical field, improvements to the functioning of the computer itself, and this comes from the earlier guidance of Deere. Applying the judicial exception with or by use of a particular machine, and that's coming from P.L.C. And effective transformation or reduction of a particular article to different state or thing, that's the well-known machine or transformation test, which will also go into detail. I also wanted to highlight this last bullet here, applying a specific unconventional limitation or step. That's really kind of coming from an opposite treatment of the Mayo case. And the Supreme Court basically said that the Mayo operation, the Mayo patent, was unlike a patent on a new drug or a new way of using an existing drug. And so the guidelines kind of use that treatment to say, okay, well, if you use a specific unconventional limitation or step in your claim, then that should receive positive treatment under the Supreme Court guidance.
Although it will be interesting to see how that plays out. For instance, the Ultramercial decision, there were some steps that the court agreed were unconventional, but they still found the claims unpatentable. So, you know, again, these are guidance, not guarantees.
Correct. Okay, so then there's also, right after that section of the interim guidance, there is a bullet list of what the examiner should not consider as being significantly more. For example, adding the word apply it or anything like that to your claim. If you have say, an abstract idea of a mathematical concept and then you simply say, apply it, that's not going to do. Mere instructions to implement the idea on a computer, applying well-understood routine, the converse of what we were just talking about, conventional activities, insignificant extra solution activity, and just simply linking the abstract idea to a particular technology, that will not be enough. So what does the examiner have to do in order to meet their prima facie burden in issuing a 101 rejection? Well, first off, when dealing with an abstract idea, they have to identify that abstract idea by referring to where in the claim it is recited. So they need to pinpoint in the claim, okay, you recited a mathematical concept and nothing more than that. Here it is in the claim. Here's the feature that recites it. And the examiner actually has to provide an explanation on the record as to why that's considered to be an abstract idea. And the examiner also needs to identify what's left in the claim, the other elements of the claim, and as part 2 of the test, identify why they do not add significantly more. There's also in the interim guidance a section that talks about streamlined eligibility analysis. And whether or not a judicial exception is recited, and even if a judicial exception is recited, if the claim clearly does not preempt that abstract idea, then the examiner does not need to engage in a full analysis. And the example provided by the interim guidance is a robotic arm assembly that operates using mathematical relationships. Now, there probably is an abstract idea in this case, mathematical relationships. But the robotic arm assembly is such a specific application of those mathematical relationships. There's so much more to it than just that abstract idea that it would be a waste of the examiner's time to really go through the full Mayo analysis in this case. And so examiners are permitted to streamline that analysis and simply say, okay, this is statutory under 101. So the question here is, what do we do with the software innovation given this uncertainty in the law? And now that we have the preliminary or the interim guidance, some may ask themselves, okay, what does that mean for applications that are currently pending, patents that have already issued, and applications that we're currently drafting? What you see here on this slide is the proverbial pendulum swinging in one direction and coming back from the other direction, where a broad eligibility to now narrow eligibility. We're currently on the very narrow eligibility side of that pendulum on 101. So a lot of folks may be asking themselves, do we continue to invest in patenting software applications? Right now, the kind of knee-jerk reaction to the guidance coming from the Patent Office, the Federal Circuit, jurisprudence, the Supreme Court, the knee-jerk reaction might be to, okay, we're just going to abandon every piece of software application that we have out there. We're not going to pay maintenance fees on issued patents because none of this is going to be worth our time. But we expect the pendulum to swing back in the other direction. Probably not to where we were before, certainly not to the full broad eligibility that we had in the years leading up to this. But we do have some ways of dealing currently, even with the pendulum all the way to the left, dealing with new application filings, pending applications, and how to wait it out until the pendulum swings back to the right. So what do we do about new applications? How do we handle this so we can, when we end up in prosecution or possibly end up in litigation, survive an attack under 101? So we have some bullets here on what one needs to think about in drafting an application. And some of this goes against kind of the conventional guidance that you may have heard in years prior. Try to keep applications succinct, don't say too much in the background section. You still certainly don't want to admit to anything as prior art if you don't have to. But one approach you may want to consider is really expanding your background section. And one way to do that is to articulate the state of the art of the application in the background section. You want to provide some context so that when an examiner or the board or a court is looking at the inventive concept, they have a backdrop to which they can compare it to and understand that this is truly a novel invention, even in the 101 context. You still have to be careful that this background can't be used against you, but you have to weigh that against the eligibility requirements under 101. And using that background section, now you have some framework in which you can articulate the improvement that the invention provides relative to that background section. Always want to understand the technical contribution and take the problem-solution approach to identifying what that improvement is. So in general, we're going to have to say a lot more than we have been saying before.
Right. And if I can add one thing, a lot of the court cases dealing with 101 lately have looked to see sort of if there is a technical problem that's being solved. It's not in such explicit words, but if we look at the bulk of the decisions that have been coming out, it seems to me moving towards this problem-solution kind of concept. What is the technical problem that's being solved? What is the solution embedded in technology here? Something more than just what a human does or things like that. You can see this also in the laws surrounding covered business method patent reviews and what's required there to be eligible for CBM review. And even some of the dicta in the Federal Circuit cases, some of the concurrences and dissents that we've seen in for instance, Ultramercial and in DDR Holdings, where it talks about this, entrepreneurial versus technological. You want to have enough in your application such that if the law continues to move in that direction, such that your application is being examined a few years down the road, or if it's being enforced in front of a court, a few years after that, you have enough in your background and in your application as a whole to survive that kind of a rigorous analysis. We don't know if that's exactly where the law is going to go, but I think just reading the writing on the wall, things are just very strict, and we don't know how soon the pendulum will swing back or exactly where it will end up. So where you, as P.L.L. mentioned, might not normally have done some of these things because you didn't want to unnecessarily limit your patent, for cases where 101 is going to be an issue, it's a decision of, well, I'm going to put it in there because otherwise I won't be able to get a patent at all. And so it's those kind of weights that have to be given to each one of these considerations.
Right. Yeah, Michelle, it's a big difference from the past where we were kind of always looking at the broader picture and we were always trying to figure out how we could get broad eligibility for everything. Now it's a tough choice between getting a patent at all and really just trying to capture too broadly what we tried to get. If we turn to this next slide here, you can see how that plays out in claim drafting. To the extent possible, we say that because you're not always going to be able to apply all of these approaches, but you're going to have to consider getting something a little bit narrower than you might have in the past just to overcome these 101 issues. Now, this is going to apply differently whether you're in something a little bit more technological as far as software. You're in the guts of a computer in that piece of software you're developing, or if it's a piece of software but it's more business method oriented. There's going to be a continuum of what the best approach could be in this case. But to the extent possible, these are some tips of how you might want to draft claims to avoid or preempt 101 issues. And the first one is you want to sort of intertwine the hardware and devices into the claim, really integrate them. And this is something more than just like we had done in the past, maybe simply reciting a computer as part of the claim. This is more like DDR Holdings. This is more where the software itself is so tied to that computer implementation, mimicking the look and feel of a web page. There's no way you're going to do that without that computer context. That's what we're talking about here. And really build into those claims that technical improvement. Now keep in mind, as I said a moment ago, the examiner has to conduct claim-by-claim analysis. So we can still push the envelope on the broader claim and build in some of these considerations into dependent claims. So we can still play around a little bit with that, especially as the case law develops around this. We want to keep those opportunities open to us.
One idea that has been floated, and we haven't really explored this in much detail and don't know what the PTO would do with it, but when you see the word improvement, you might think Jepson claims. And those have been out of favor for a while, But one possibility is that for 101 or claims that may have 101 issues, software-style claims, business method claims, a Jefferson-style claim where you're reciting what the improvement is in very explicit terms may be something that works.
Absolutely, absolutely. And in some cases, the chemical arts may have, our fellow practitioners in the chemical arts may have been ahead of us by about 30 years in how we handle software claims. Another bullet here is, to the extent that you can, again, avoid Art Units 3620 and 3680 for electronic commerce. The reason this is under claim drafting strategy is if you can couch an e-commerce type invention into, say, a database type invention, you may end up being examined by a more favorable art unit than the e-commerce art units. That's a very tough thing to do, but something to consider. So now we're turning our attention to what you do once you're in prosecution and different strategies for moving things forward with the examiner. One approach, and I alluded to this a moment ago, is to really find similarities to the DDR Holdings case and some of the language that's come out of the interim guidelines, and differentiate yourself as much as you can from our ultramercial. Now, of course, all the guidance we're providing in this section requires you to draw from an already written specification. And so if you haven't had the opportunity to apply the knowledge that we've given you, the tools that we've given you from the past few slides, unfortunately you may be stuck with something that doesn't have kind of that context of the background and so on. But to the extent that you can do these things with the specification you have, this is the approach we would recommend. The next thing is to really require the examiner to fully lay out the rejection. They need to provide a prima facie Section 101 rejection. If you're in the 3600 art units, you may want to delay prosecution until you get some more clarity on how this is all going to play out within that art unit. Or at least if you can push back the 101 issues so you can move forward on the art-based rejections, anything else you have outstanding, you may want to consider doing that. It's not necessarily the best idea to kick the can down the road, but it may be ideal in certain cases, and we'll talk about those considerations in later slides. Where it makes sense, where the examiner is just not being helpful, you may want to consider appealing the case, and a pre-appeal brief or meeting with the SPE before you go on the full appeal, that's also something that might move things forward. Not so fast with the ALICE analysis. You need to make sure, as I mentioned earlier, that the examiner has fully laid out the case. So before you take it upon yourself to consider all these different factors, to lay out your entire case and put on the record all of these ideas, you may need to make sure that the examiner has fully stated for the record what the rejection properly is. Similarly, don't jump into Part 2 of the ALICE analysis without really considering the issues around Part 1 and the scope and the evidence and everything that the examiner has laid out in consideration of that. As we know from the In re Jung case, the office has this procedural burden of establishing the prima facie case, and all we're suggesting in this stage is that you make sure that the examiner has met their burden, not as a way of necessarily just kicking the can down the road and making sure that they fully flesh it out, but so that you can be fully responsive, because these issues are a lot more difficult than the 101 issues we've dealt with in the software arts in the past. This isn't something that you can just kind of template, throw in on a computer or anything like that. You need to really understand what the examiner thinks is the abstract idea, what the evidence is for all of that before you can fully be responsive.
And another important reason for doing that is even if you can make it through the examination process and get your patent issued, you want there to be a clear understanding of what was argued and what the examiner's position was and what you overcame, because if you go to enforce the patent, you want the judge to be able to rely on the analysis that happened at the patent office and not start over from scratch and then realize that you hadn't addressed certain issues.
So some positive news is that the interim guidelines provide some fairly explicit requirements that the examiner must meet in order to provide this prima facie case. And As I mentioned earlier, one very nice part of the interim guidelines is that the examiner must address all parts of the claim and all of the claims of the application. So if you've laid out claims in a nice continuum of not just art-based considerations as we've normally done in the past, but also a spectrum of 101 breadth, then you can make sure that the examiner is addressing those dependent claims. You might get some clarity as to the proper direction for the claims to overcome 101. And also the examiner needs to identify the abstract idea with particularity. So we've provided a checklist in the next couple of slides for Part 1 and Part 2 of the analysis for what the examiner really needs to state in the rejection to establish this prima facie case. First is the purported abstract idea clearly identified? And to do that, the examiner needs to first single out the specific abstract idea. What does the examiner say is this overarching abstract idea? Maybe they've gone too broadly. Maybe they've gone too narrowly. You need to understand what the examiner thinks that is. And second of all, the question of whether the abstract idea is appropriate for all of the independent and dependent claims needs to enter into consideration. Moving on to Part 2 of the analysis, you need to consider whether the examiner has performed a full analysis of all of the elements. So now that you have the abstract idea in mind, you need to look at the totality of the elements in order to understand whether the examiner has done more than simply restate the requirement. Yeah, the claims do not amount to significantly more than an abstract idea. Well, why not? There are these other elements in the claim that the examiner hasn't really considered and hasn't articulated a basis for that rejection. So you need to hold the examiner accountable to that. And also, has the examiner properly considered all of the elements individually and in combination? Has the examiner considered the claim as a whole? All of this is laid out in the interim guidelines, and so you need to consider whether the examiner properly followed this in making their rejection. Now, it's not enough to simply state, yes, there's nothing more than the abstract idea. The claims do not amount to something more. The examiner has to provide evidence supporting their position. If the examiner is saying that their purported abstract idea is X, they need to provide evidence that that is, in fact, an abstract idea. It's not enough, for example, for the examiner to say, yes, this is a fundamental economic practice, or this is just a method of organizing human activities. They need to state why. And one way that the examiner could do this is, obviously providing some extrinsic evidence to the effect, but more commonly I would expect that the examiner would take official notice of this fact. In my experience so far, examiners haven't been doing either properly, but if they are going to take official notice, do keep in mind that the examiners have a specific procedure that they need to follow in order to take official notice, and that is laid out in MPAP 2144.03. Also important to keep in mind is that whatever evidence the examiner lays out must actually map to the claims, and they need to show that mapping as the basis for their rejection. And with that, I'm going to turn it back over to Michelle to walk you through the rest of the presentation.
Thanks, Al. So we've been talking about the requirements and what the examiner is required to do under the guidelines, but what should an applicant do when they're faced with this? Right after Alice, we saw a number of office actions with 101 rejections that were very short shrift. I think the examiners didn't quite know what to do in that case, but now we have the new guidelines which detail very explicitly the type of analysis that an examiner has to go through. We're just now seeing the first office actions after the 101 guidelines, and so we don't yet have a good idea of whether examiners as a whole are moving to this more detailed analysis, or whether we'll still see some of these broad brush, lump all the claims together types of analyses. So a couple questions you have to ask yourself on how detailed should your response be. How much do you attack the prima facie case? How much substance do you argue? Well, this really depends on the importance of the case. It depends on the strength of your position. It depends on how good of a job the examiner has done. I think going through, we're going to assume that the examiner's done a good job based on the requirements and the guidelines, but as Sal's mentioned, there's always things, you can attack for the prima facie case if you don't think that the examiner has put sufficient information on the record that you can respond to. So let's walk through each of the concepts and talk about how you might get into the substance and substantively address a 101 rejection. So in part one, there are several different quote-unquote abstract ideas that the guidelines refer to. One of these is fundamental economic practice. So the examiner may try to say that your idea that the claim is directed to is a fundamental economic practice. Some ways to try and overcome that and say, well, no, this is not a fundamental economic practice. Maybe you have an expert declaration showing that this purported idea is not fundamental or is not an economic practice. I think economic is just based on the facts of the P.L.L.C case, but any fundamental practice I think that they would get into for whichever technology. You want to be able to show that, no, this isn't fundamental. Maybe it was a problem that at the time the application was filed was fairly recent. Now, in hindsight, it may seem ubiquitous, but at the time, it was a real issue that people were struggling with. A lot of times in the software arts, we tend not to submit expert declarations, but this might be an occasion where that's useful just to make sure everyone is on the same page with an understanding about the state of the art. Also, you can argue that the claims practice exists only because of that particular technical implementation. So maybe there's this fundamental practice, or maybe it only exists, it's not fundamental because of this one technical problem. And so there you would try and argue that there is a technical effect and that it doesn't preempt the abstract idea. One of the other abstract ideas that seems to get a lot of attention is this methods of organizing human activities. And if you think about it, just about anything is a method of organizing human activities unless they really cannot be performed by a human. And there are certain tasks, such as the DDR holdings case, where it dealt with the specific way that information was assembled into a web page and displayed on a computer. That requires a specific machine implementation to operate. These types of things can't be performed by a human. A human can't receive certain types of signals and generate, other information. So if there are certain data constructs and software interfaces that are required, try and point to those, again, to show that you don't preempt some abstract idea and to also to show that there is a technical effect. Something else to think about is whether the breadth of the abstract idea is correct. This is the one area that I think we'll see the most difficulty on. Examiners don't have a lot of guidance on identifying the abstract idea. Once an abstract idea is identified, the guidelines tell you what to do with it. They tell the examiners how to figure out if something is meaningful. But when trying to figure out what the abstract idea is, there's virtually no guidance on that. They have some examples, but that's about it. So we expect to see a wide variety in the breadth of the abstract idea. So if you have a broad abstract idea, that might work in your favor because then you will be able to show that your claim does not preempt that abstract idea or that there are meaningful distinctions once you jump to part 2 of the analysis. Similarly, if you are faced with a narrower abstract idea, you may be able to show, well, this is not fundamental, or this is not something that's present, can be done in the human mind, or a method of human activity.
And I wanted to add on this point that it's very rare that you're going to be able to show that there is no abstract idea at all, that the claims are not directed to an abstract idea, since the requirement is simply that there be a recitation of an abstract idea. And as the guidelines note, and this is probably going to be the case, most inventions are going to at least be directed to an abstract idea. There's going to be an abstract idea in there somewhere. So as Michelle noted, really what you're doing here is focusing on, is the abstract idea that's been recited properly scoped? Is it broader? Is it narrower? And is it to your liking, frankly? because there are advantages and disadvantages to a broader or narrower abstract idea.
Right. Even the Federal Circuit struggled with this in the DDR Holdings case. They really struggled to define what the abstract idea was. So that's why they focused most of their attention on Part 2. But one other case that I just wanted to mention in talking about this, just as an example, was the McRow Planet Blue case that recently came out of the Central District of California. And just as an example of what you might see, and I think this would be a surprise to a lot of people who are software patent applicants, but in that particular case, the claims dealt with automated lip synchronization. And here's what the judge said was the abstract idea. So the abstract idea was the field of automatic lip synchronization for computer-generated 3D animation using a rule-based morph target approach. Now that sounds pretty detailed, and the judge found that that was an abstract idea. So, of course, if the claims are directed towards focusing on the lip synchronization, focusing on 3D animation, using this rule-based morph target approach, well, of course, the claims preempt that idea because that is what their innovation was. And so the judge there found this narrow abstract idea. So in that case, you might be stuck with just arguing that it's too fundamental because you're going to have a hard time in a case like that arguing additional meaningful distinctions on top of that without substantially narrowing your claim. So just something to think about, when you get these abstract ideas. Expect to see a variety of scope. It'll really be, I think, dependent on the examiner and the art unit, and to the extent that you go into litigation, even the judge there. So you have to be flexible on your approaches. So once we get into Part 2, we have the meaningful limitations. So what you're trying to do here is take the abstract idea and show that there's something more than just the abstract idea cited. Ways to do that, if you can show that you've improved another technology or technical field with the abstract idea, that's kind of like the Deere case where you had this mathematical concept, but you figured out a better way to cure rubber by using it. That's one option. Certainly improvements to the functioning of the computer itself. This is very similar to the technical arts test in Europe. In the EPO, they don't allow software per se, but if you can show that the change actually affects how fast the computer runs or how it operates, maybe there's a more efficient mode of operation there, then that can overcome the issues, and I think the same would apply here. Anything else beyond conventional steps? As we mentioned earlier, that's one that you have to give some weight to or some balance to. The ultramercial case acknowledged that the claim recited unconventional steps that were unique to that particular field, but found that it still wasn't sufficient to meaningfully limit the abstract idea that was recited in that case. But still, it's worth arguing, and certainly in many cases, that unconventional aspect, particularly if it is directly related to the core of the technology, that's going to be where your arguments lay for overcoming the abstract idea.
So, Michelle, it sounds like what you're saying is that given the there are certain decisions that have had negative treatment of any one of these meaningful limitations and positive treatment of some of these meaningful limitations. So you may want to identify as many of these as you can in your response and hope that at least one of them sticks, right?
Right. And again, because there's no consistent sort of rule of law here that we can point to, you're really at the whim of what's important to the examiner as to what he'll agree with, what he believes is conventional or an improvement to the computer, things like that, and how important it is. And it really comes down to, what is the focus of the claim? And this is a case where interviews, may be really useful, and just sitting and talking with the examiner to make sure you understand where the examiner is seeing the abstract concept and trying to figure out what you can do. Another thing to consider is the machinery transformation test. This test is still a valid test. It's, as the Supreme Court has reminded us, it is not the only test, but it's a useful clue. And certainly if you pass the machinery transformation test, that is helpful in arguing your 101 eligibility. Now, the courts have reminded us that passing the machinery transformation test isn't a guarantee, but it's certainly a solid point in your favor.
And it is specifically singled out in the interim guidelines, so
right.
That's another positive for it.
Right. And when we're talking about what does this mean in the context of software, and of course, if you're operating a physical device in using software, and you have that recited in your claim in more than just a field of use limitation, that's going to help. But there's been some recent decisions that indicate that transformation of data may qualify as a transformation under the MRT test. Now, maybe the data is representative of a physical object. DDR Holdings alluded to this in its decision when it talked about how the data changes from one construct to another. There have also been some decisions from the PTAB in CBM's post-Alice that have indicated that certain types of data transformations, in particular contexts, of course, but those can satisfy the machinery transformation test. Something else to consider arguing is the point of novelty approach. So if you can point to a specific point of novelty that's implemented in technology, so you automatically know that it's not found in the prior art, so it can't be fundamental, those types of technical effects may be very, very useful and persuasive to an examiner. And I'll mention that this point of novelty test, so the point of novelty test is not the test. It's just one of many that might be able to be used. In the Grow Planet Blue case that I was just mentioning, point of novelty test is actually what the district court judge used. So, as I mentioned, there's all these tests. There's no guarantee of which one will actually be used or which one will stick, but to the extent that you can argue any of them, we'd recommend it at this point until the Patent Office and the courts settle on what they consider to be the most likely approach. Another thing to argue is to argue your dependent claims. Sometimes your dependent claims, they are narrower, but they present more detail or focus in on a particular implementation, and that might be helpful for 101 as well. So just to summarize, things to do in prosecution, you can attack the sufficiency of the rejection, and ways to do that is you maybe interview with the examiner, challenge the sufficiency of the 101 rejection. The goals in all of these are to request a new office action. If the examiner hasn't given you enough detail to properly respond, any substantive response you make that makes assumptions on the part of the examiner is really just arguing against yourself, and it may or may not be what the examiner was actually considering. So you really need to have that information from the examiner. At the same time, because you couldn't properly respond, they should not make the next office action final. So you should explicitly point that out and request a new office action so that the first time you get a full rejection and have the ability to respond, you're not hit with a final rejection. Another thing you can do is look at the PTAB CBM decisions. They are dealing with 101 post-P.L.L.C. on a more expedited basis than the courts are, and they're issuing a lot of decisions. So we're able to find a number of useful types of analyses from there. Most of those CBM decisions are not precedential, but when you're just looking for guidance on how the Patent Office might be interpreting certain terms or the guidance, these CBM decisions can be very useful. And in terms of your substantive strategy. So we've talked about how to best argue the merits. You may also need to amend the claims. I think there's certainly claims out there, especially if the applications were filed before Alice and before the recent focus on 101. It was a very different style of drafting claims, mainly because that's what the previous guidance from the Patent Office had told us to do. So, claims that might have been totally fine when they were filed now may need amending. So you should consider how best to do that, and not be too afraid of amending your claims, especially if it'll result in overcoming a 101 rejection. Make sure you're looking at the shortcomings of the examiner's evidence there. You might consider an expert declaration, as we've discussed. And there is going to be the scenario sometimes where you have to delay or abandon the case. If you look at the claims and you go through the guidance and you really cannot make those substantive arguments, because maybe it really is a lot like the Alice decision the Alice claims or the ultramercial claims. These are things you have to consider, and you may have to strategically abandon some cases. We're not saying to do that for all of them, but certainly that has to be an option that you consider, particularly if it's a case that's not as important to your overall strategic plan. So along those lines, do companies continue to invest in business method and software patents? I think the answer is yes, but you want to do it strategically. So we've been talking about these guidelines, but some important things to remember in the overall context of the forward outlook on business method and software patents. These PTO guidelines do not have the force of law, and courts aren't bound by these guidelines. So these guidelines exist now. In a couple years, they may change. If you stop all patenting or take certain things in response to these guidelines, it may be different in a couple of years. Another interesting thing to think about is the last time there was a legal change, an actual change in the legislation on Section 101 was in 1952. All the law since then has been judicially created. These exceptions which came out of the cases in the 1970s, that was all the judicial branch trying to best understand the law as passed in 1952. Even the AIA, although it talked about covered business methods, it did not get into statutory subject matter. That was something that seemed that that Congress explicitly decided not to address. There's always talks of further patent reform, further legislation to clear up some of these issues, maybe specifically deal with the question of are business methods and software patentable. Right now they are, and the legislation has not spoken otherwise. So just something to think about when you're coming up with your overall strategy for protecting software innovation. If we look at it, even over the past 5 years, there have been such significant changes in the law that unless you look at some innovation and really there's no there, you should look at it strategically. So what are some questions that you should ask when you're deciding whether to continue investment in certain software IP? I think this goes for new applications as well as issued patents where you're looking at maintenance fees, and certainly whether or not you file an RCE to have the argument on 101 keep going or respond to office actions. So is the invention important to your company? Is it technological or entrepreneurial? That kind of goes along the lines of Judge Mayer's statement, both in his ultramercial concurrence and then the DDR dissent. That goes to the strength of what arguments you'll have to raise against a 101 rejection. Is anything created by the invention, or is it purely virtual? Does it involve a physical thing? Is it a fundamental invention? Is it groundbreaking, really changing the industry, or is it a minor incremental invention? It kind of goes to the next question of whether it's revolutionary. Will it be implemented? Does your company intend to enforce or license the patent? all of these questions go to what is the value of that innovation. And I think when you're dealing with software innovation where you know it's going to be a challenge to get it through the patent office and then a challenge to enforce, this is how you decide whether you're willing to invest in that challenge. And you have to look at how valuable it is. What is your motivation for filing this application? You know, if it's to prevent competitors, that's probably pretty important. If it's to simply reward inventors for a job well done, maybe not. You know, these are all things you have to look at, from the reasons that you're filing to what you ultimately intend to do with it. Maybe you're trying to build a strong portfolio for an IPO. These types of things will give different answers to the same question on a given piece of software, and whether you try and patent that technology. And for your current portfolio, just something that you may want to think about now that we at least have, I think we'll have a somewhat of a focus on these guidelines. You know, for the past year, while we were waiting for the Alice decision and then waiting to see what the Patent Office would do post-Alice, there was a lot of uncertainty. I think if you asked any of us what the rules were going to be, we couldn't tell you. Certainly the rules may change, but I feel like we at least now have some guidance and an indication of how the PTO is going to be looking at these cases. And perhaps that'll also give us some indication of what courts will do as well. Obviously, the courts aren't bound by the PTO guidelines, but as the Patent Office tries to come up with broader examples, you know, it's something that we may be convening on a particular stage in 101 provenance here. So, you know, you need to evaluate how vulnerable your portfolio is to 101. There are certain things that can be done if you find that you know, you got a case issued pre-Alice and thought everything was good, did everything you needed to do that the Patent Office required you to do, but now you realize post-Alice that the same analysis doesn't apply. Some of these remedial measures include, you know, if you're still within the 2-year window for a broadening reissue, well, maybe you do that because there's been a change in the law. There is an option for supplemental examination. So normally, ex parte re-exam is not available for 101 type issues, but if you go in through supplemental examination because of the recent changes in 101 law, and the office finds that there is a substantial new question of patentability, they will institute an ex parte re-exam and allow you to try and fix any 101 issues through that re-exam. And that's probably a more favorable methodology than being in front of a court trying to argue, you know, sort of the old style claims. So if there are any questions, feel free to send them in, or you can contact either one of us afterwards. This is still quite of a change. I guess it's an area that is still in flux, though we have some certainty, at least for now, from the Patent Office as to what they're going to try and do. The Patent Office also mentioned that examples of software patent claims should be posted to the PTO website imminently, was the last word I heard as of yesterday. They already have examples for natural law-based claims, but they hope to have some abstract idea style claims coming up. And with that, I think we are open for questions. Okay. All right. Now, I don't believe we have any questions, so I think we'll go ahead and just close it up. Should you have any questions that come up later, feel free to contact us. And thanks very much for your time.
Thank you all so much.
Great. As I stated before, if you'd like to receive a PDF copy of today's presentation, please send an email request to Erin West at ewest@skgf.com. We'll also have this recording available shortly as well, and you can request a link to that as well. Thanks so much.